Good morning, class. Settle down, please. Right, I need you to pay very close attention today because what we're unpacking in this explainer is the ultimate KSLU exam answer blueprint. If you're aiming to secure a solid 16 marks on the Transfer of Property Act 1882, this specific topic is absolutely indispensable. We are looking at property law, the right of redemption and clogs on redemption. Now remember, the evaluator is not looking for stories, okay? They are looking for precise statutory provisions, clear essentials, and landmark case laws. So have your notebooks ready, let's begin.
Here is the exact structural sequence you will follow. 1. Introduction to Section 60. 2. Essentials and Nature. 3. Rights on Redemption. 4. The Core Doctrine. 5. Clog on Redemption. And 6. Landmark case laws. You need to immediately note down this exact sequence, as this is the precise table of contents the KSLU evaluator expects on your answer script.
All right, heading number 1, Introduction to Section 60. Right of redemption, the right of the mortgagor to recover his property by paying the mortgage money after it becomes due. Section 60, Transfer of Property Act 1882. Now listen carefully. When you begin your formal answer, you must clearly and immediately establish the statutory recognition of this right. You do not start with vague definitions, right? You start with the bare act. And in your exam paper, you're going to put Section 60 in a separate, neatly drawn box. Take your ruler, take your pen, and box it. This immediately captures the evaluator's attention. It shows you know exactly where this right emanates from. The mortgagor has taken a loan, provided property as security, and the absolute moment that principal money is due and paid, the right to get that property back is triggered.
Moving on to heading number 2, Essentials and Nature.
1. Mortgage money must have become due. 2. Mortgagor must pay or tender the amount. 3. Redemption must be before foreclosure or sale. It is mandatory for you to break down a statutory right into its essential elements like this. Note the numbering on the screen. Numbering these 3 essentials explicitly is absolutely crucial for scoring maximum marks. The examiner is actively looking for these 3 triggers. First, the time for payment must have arrived. You cannot redeem prematurely unless there's a specific contract to the contrary. Second, you must actually offer the money. Mere intention is not enough. And third, this right exists only until a court decree of foreclosure or an actual valid sale has extinguished it. So write them as 3 distinct numbered points.
Statutory and equitable right cannot be taken away by agreement, continues until legally extinguished. Now, why do we include this? Citing that this is a statutory and equitable right demonstrates deep conceptual clarity to the examiner. It means that not only is it codified in Section 60, but it is also heavily protected by the courts of equity. The parties cannot just sign a piece of paper waving goodbye to this right at the time of making the mortgage. Absolutely not. The right survives until the law itself puts an end to it.
Next, heading number 3, Rights on Redemption.
Return of possession, return of documents, retransfer of property. We've discussed the concept, but you must list the practical outcomes in your answer once redemption legally occurs. Read those again mentally. Return of possession, return of documents, retransfer of property. Class, these 3 specific physical rights form the tangible outcome of Section 60. If I give you my land as security, and I pay you back, I must get actual physical possession back if I had delivered it to you. I must get my original title deeds back so my title is clean, and you must execute a retransfer or registered acknowledgement showing the mortgage is cleared. Do not forget to list all 3 sequentially.
Heading number 4, the Core Doctrine. Once a mortgage, always a mortgage. Mortgage is always redeemable. Any provision preventing redemption is invalid. This is the most critical equitable maxim that absolutely must anchor the center of your essay. If you miss this, you lose significant marks. Mark my words clearly. I want you to write once a mortgage, always a mortgage in all capital letters right in the middle of your answer booklet, and I want you to underline it twice. This principle established by the English courts of equity means that a transaction which at its inception was a mortgage will retain its character as a mortgage forever, until it is redeemed or legally foreclosed. You simply cannot disguise a mortgage as a sale to trick a borrower.
Which brings us to the second distinct half of the university question. Heading number 5, Clog on Redemption.
Clog on redemption. Any condition that prevents, restricts, or hampers the mortgagor's right to redeem. The general rule, any such condition is void. The examiner wants to know what happens when someone tries to place restrictions on this right. I want you to actively dissect those 3 words in your exam: prevents, restricts, or hampers. You see, a clog doesn't just mean a total absolute ban on redemption. Even if a condition merely makes it unreasonably difficult or hampers the process, equity will step in and strike it down. And what is the consequence? Command your pen to heavily emphasize the word void. The condition is void, but the mortgage itself remains valid and redeemable.
Absolute restraint on redemption, unreasonable time restrictions, collateral advantages, conversion into sale, oppressive terms, what actually amounts to a clog? Well, here is your mandatory 5-point checklist. The examiner will actively search your paper for these exact 5 points. An absolute restraint means a clause saying you can never redeem. That's void. Unreasonable time restrictions, like saying you cannot redeem for 99 years, that is a clog. A condition converting the mortgage into a sale automatically upon default, a void clog. Write these 5 down exactly as they appear.
Reasonable conditions, fair collateral agreements, separate independent contracts. Now, what is not a clog? Contrasting what is a clog with what is not a clog proves comprehensive mastery of the syllabus. It shows you really know the nuances. A reasonable condition is completely fine. A separate, entirely independent contract made later on between the exact same parties is not a clog on the original mortgage.
Void clog, redeem only after 100 years, versus valid, supply goods to mortgagee at fair price. Let us compare them directly. I am strictly instructing you to draw a similar comparison table in your exam. Put a line right down the middle of the page. On the left side, put the 100-year example, clearly labeling it a void clog. On the right, put the collateral agreement to supply goods at a fair market price, labeling it valid. Creating this table saves you precious time writing long paragraphs, and it highlights key concepts cleanly and sharply for the evaluator.
Finally, heading number 6, Landmark Case Laws.
Kreglinger v. New Patagonia Meat Cow. Collateral advantage valid if reasonable. This is the mandatory requirement for any high-scoring KSLU legal answer. I want you to underline this case name in your exam paper. Let's break this down. What were the actual facts of the case? The meat company borrowed money from Kreglinger, who were a firm of wool brokers. The agreement stated Kreglinger would lend the money, but in return they wanted the right of first refusal to buy all the sheepskins the meat company produced for 5 years. Well, the meat company paid back the loan early and argued that the 5-year sheepskin agreement was a clog on their right of redemption and should be completely void. So what was the ratio decidendi? The House of Lords held that the collateral advantage, buying those sheepskins at market price, was a completely separate and fair business deal. It did not prevent them from getting their property back. The absolute relevance of this case is profound. It teaches us that not every single extra benefit to the mortgagee is a clog. If it is a fair, reasonable collateral agreement, it stands. Put this case in a separate boxed format to immediately capture the evaluator's attention for those full 16 marks.
Narandas Karsandas versus S.A. Comtum. Emphasized importance of right of redemption. Again, underline the case name. This is a supreme Indian precedent that acts as the ultimate authoritative stamp to validate your entire argument. In this case, the Supreme Court of India was examining when exactly the right of redemption extinguishes in the context of a sale. The brief facts revolved around a property being sold to recover dues and the mortgagor desperately trying to redeem it before the sale deed was fully registered. The ratio decidendi. The court categorically stated that in India, the right of redemption is a statutory right under Section 60, and it is only extinguished upon the actual execution and registration of the sale deed. A mere contract of sale does not extinguish the right. The absolute relevance of this case is that it reinforces how fiercely Indian law protects the mortgagor. Add this to your answer to show your knowledge isn't just limited to Old English equity, but is deeply grounded in modern Indian Supreme Court rulings.
Mortgage remains only a security for debt. Any attempt to defeat this right is a clog and void. Preserves fairness in mortgage transactions. Class, write these exact concluding phrases to secure those final marks. A mortgage is never a transfer of absolute ownership, it is merely security for a debt. The moment the debt is cleared, the security must be returned. Any tricky condition drafted by a clever lawyer to trap the borrower is a clog, and equity will absolutely crush it as void. This strict framework preserves fairness in all property transactions. I want you to memorize this blueprint exactly as we have laid it out today. Organize your headings, box your statutory provisions, and underline your case laws. But before I dismiss you, I leave you with this question for your future legal careers. As modern financial lending becomes more and more complex, filled with hidden terms and algorithms, how will the courts of tomorrow continue to spot the invisible clogs meant to trap the vulnerable borrower? Think about that. Class dismissed.